Hello everyone, good day. Today we're going to talk about the RA 7877 or the Anti-Sexual Harassment Act of 1995. So, the section 1 of this RA 7877 is the anti-sexual harassment. So, here it means that an act declaring sexual harassment unlawful in the employment, education, or training environment and for the other purposes. So, it means that this RA 7877 is it is an act that is against sexual harassment in the employment, education, or training environment and for the other purposes. So the section 2 of this declaration of policy, the state shall value the dignity of every individual. So it means that every individual, uh, their dignity is being valued, being protected, enhance the development of its human resources, guarantee full respect for human rights, and also uphold the dignity of workers. So, employees, applicants for employment, student, or those undergoing training, instruction, or education toward this and all forms of sexual harassment in the employment, education, or training environment are hereby declared unlawful. So, the section 3 is work, education, or training related sexual harassment. So, let's talk for the work first. Work related sexual harassment. The sexual favor is made as a condition in the hiring. So it means that sexual favor is made in the condition of high in the hiring or the employment. So before they are offering a condition to you uh, f- for you for being hired or for being employed, the employment or continued employment uh, of the said individual. So even re-employment or continued employment, or in granting said individual favorable compensation, terms, condition, promotions, or privileges. So even terms, condition, and promotion or the privileges, or the refusal to grant the sexual favor, resulting in limiting, segregating, or classifying the employee, which is in a way would discriminate, deprive, or diminish employment opportunities, or otherwise adversely affect said employee. So also sexual favors resulting in limiting your rights or your employment's rights or your labor rights. And then the above act would impair the employee's rights or the privileges under existing labor law. Uh, or the above act would result in an intimidating, hostile, or offensive environment for the employee. And also for the education, training related sexual harassment. So, against one who is under care, custody, or supervision of the offender, against one whose education, training, apprenticeship, or tutorship is entrusted to the offender, when the sexual favor is made a condition to the giving of passing grade or granting of honors and scholarship, or the payment of stipend, allowance, or other benefits, privileges, or consideration. So, this is the education or training related sexual harassment. So I guess the third one is really common to us. We can see it in the movie and also from the news that some teachers asking for sexual favors at giving passing grade and a scholarship allowance. And when the sexual advances result in an intimidating, hostile, or offensive environment for the student, trainee, or the apprentice, any person who direct or induces another to commit any or of sexual harassment as herein defined, or who cooperates in the commission thereof by another without with which it would not have been committed shall also be held liable under this act. So even if uh, someone is not the one who harassed you, but they are cooperating to harass you, they are also held liable under this act. So sexual harassment may take place. So this is the uh, sexual harassment may take place in the premises of the workplace or the office of the school or training institution. So in the work school premises, in any place where the parties were found as a result of work or education training responsibilities or relation, at work or education or training related social function, while on official business, outside the office or school or training institution, or during work or training related travel, uh, at official conference, fora, symposia, or training sessions, by telephone, cellular phone, fax machine, or electronic mail. So, the sexual harassment uh, is not sexual harassment place is not just limited to physical environment, but also in a telephone, cellular phone, fax machine, or electronic mail can also uh, uh, sexual harassment also may occur. So, illustrative forms of sexual harassment. So, this is the forms of sexual harassment. So, physical, malicious touching, overt sexual advances, gesture with lewd insinuation, and verbal also, requests or demands for sexual favors and lurid remarks. Others, use of objects, pictures, or graphics, letters, or writing notes with sexual underpinnings. Classification of sexual harassment. So, this is the classification of the sexual harassment. So, grave offenses, unwanted touching of private parts of the body. So, the genitalia, buttocks, and breast. And two is sexual assault, malicious touching, requesting for sexual favor in exchange for employment, promotion, local or foreign, travels, favorable working condition or assignment, a passing grade, the granting of honors of scholarship, or the grant of benefits or the payment of stipend or allowance, and other analogous cases. So this is the grave offenses, and for less grave offense, unwanted touching or brushing against victim's body. So it means unintentional pinching, not falling under grave offenses. Derogatory or degrading remarks or innuendos direct toward a member of one sex or one's sexual orientation are used to describe a, a person. So it means that even if you are just going to degrade their maybe their sexual orientation or their genitalia or other parts of their body, it would you can also get offenses from it. And then verbal abuse with sexual overtones and other analogous cases. Light offenses, surreptitiously looking or staring a look of a person's private part or wear undergarment. So, staring to one's person private part or worn undergarments is also an offense. Telling sexist, matty jokes or sending this through text, electronic mail, or other similar means, causing embarrassment or offense and carried out after the offender has been advised that they are offensive or embarrassing, or even without such advice when they are by their nature clearly embarrassing, offensive, or vulgar. Malicious leering or ogling, the display of sexually offensive pictures, materials, or graffiti, unwelcome inquiries or comments about the person's sex life, also unwelcome sexual flirtation advances, and prepositions, making offensive hand or body gestures at an employee. So, persistent unwanted attention with sexual overtones, unwelcome phone calls with sexual overtones causing discomfort, embarrassment, offense, or insult to the receiver, and other analogous cases. So, the section 4 is duties of the employer. So, to promulgate or to promote appropriate rules and regulations in consultation with the jointly approved by the employees or the student or trainees through their duly designated representatives, prescribing the procedure for the investigation of sexual harassment cases, and administrative sanction. Therefore, administrative sanction shall not be a bar to prosecution in the proper courts for unlawful acts of sexual harassment. And duty of the employer is create a committee on decorum and investigation of cases of on sexual harassment. So the committee shall conduct meeting as the case may be with other officer and employees, teacher, instructor, professor, coaches, trainers, and student or trainees to increase understanding and prevent incidents of sexual harassment. It shall also conduct the investigation of the alleged cases constituting sexual harassment. So it means that it is the duty of the employer to create a committee or to investigate the cases of sexual harassment happen in the work environment. So content of the compliant. So contents of the compliant. So the full name and the address of the complainant, and the full name, address, and position of the respondent. So a brief statement of the relevant facts, evidence in support of the complainant, if any, a certification of non-forum shopping. So it means that this five is if you're going to complain to the police, you will be needing these five, your full name and address, the full name of also you are uh, of the respondent, address, and in his position in the office, and also a brief statement of the relevant facts and evidence, if any. And then section 5 is the liabilities. So the liabilities are the employer or the head of office, educational training institution shall be solitarily liable for the damage arising. So it means that they are part of being liable, the employer, educational training institution, and they are solitarily liable for the damage arising from the act of sexual harassment committed in the employment, education, or training environment if the employer or head of office, educational training institution is informed of such act by the offended party and no immediate action is taken thereon. So if they were informed but they didn't act, so they will be going a part of the sexual harassment case, because it means maybe they are helping or protecting the employee or their employee also. Section 6 is independent action for the damages. So nothing in this act shall preclude the victim of work, education, or training related sexual harassment from instituting a separate and independent action for damages and other affirmative relief. Penalties: any person who violates the provision of this act shall, upon conviction, be penalized by imprisonment of not less than 1 month nor more than 6 months, or a fine of not less than 10,000 nor more than 20,000 pesos, or both such fine and imprisonment at the discretion of the court. And then any action arising from the violation of the provision of this act shall prescribe in 3 years. Section 8 is the separability clause. If any portion or provision of this act is declared void and unconstitutional, the remaining portion of or provision hereof shall not be affected by such declaration. So it means that if there are any provisions that would make the act that is declaring this act as void or unconstitutional, so this act uh, is not is will not be going to be affected. Uh, Section 9 is reappealing Repealing clause. All laws, decrees, orders, rules, and regulations under issuances or parts thereof inconsistent with the provision of this act are hereby repealed or modified accordingly. So, effectivity clause. This act shall take effect 15 days after its complete publication in at least two national newspaper of general circulation. So, I guess that's all for the Republic Act 7877, Anti-Sexual Harassment Act of 1995. So I hope you gained something, and goodbye and thank you.